you all. ID Shivraj, member of Legal Vidya, welcome you all to our highly anticipated webinar on the topic of the inception and essence of crime and the principle of criminal jurisprudence with the change dimension. Before we begin the webinar, I would like to introduce Legal Vidya to you all. Legal Vidya is a platform that was founded in the year 2021 with the vision of empowering young lawyers. The organization provides a comprehensive portal where people can enhance their knowledge and grow their expertise in the field of law. Legal Vidya offers various opportunities such as internship program, a platform to publish articles and host interactive webinars and sessions for its members. Through Legal Vidya, individuals can gain access to valuable resources, network with like-minded individuals, and ultimately develop their skills for success in legal profession. Now, I like to call Ms. Sakshi Sharma to express her gratitude to Mr. Kapil Gupta sir for joining this webinar. Ma'am, please.
Thank you so much, Risha. So, firstly, thank you so much, Kapil sir, for joining this webinar and joining Legal Vidya for this webinar on such a short notice. It is really great to have you here with us today, sir. And I do hope and I know that all our students who have joined today will surely benefit from this webinar. I'd also like to thank Risha for hosting this webinar very kindly and also to all our participants who have taken out their time to join us. And most of all, I'd like to thank Amit Bhaiya and again, once again, Kapil sir for joining us today. Thank you so much, sir, and I look forward to learning something from you today.
Thank you, Rishabh. Shall we start?
Now, now it is a great pleasure and honor that I introduce our distinguished speaker for today's webinar. Now, today's speaker is Mr. Kapil Gupta sir, an eminent advocate practicing at High Court of Rajasthan and the distinguished founder of Kapil Gupta and Associate, a renowned legal firm in Rajasthan with over 20 years of experience in the field of law. Mr. Gupta sir has established himself in expert and in evidence law and all except of criminal field. His vast knowledge, profound expertise, and insightful perspectives have made him a sought after a legal professional. As an accomplished author and speaker, Mr. Gupta sir has shared his expertise through numerous publications and engaging speaking engagements, shedding light on the complex legal matters and offering valuable insight to the legal practitioners and aspiring professionals. Uh, uh, so, without further ado, let us warmly welcome to our sir to virtual stage. We await the invaluable wisdom and perspective they are about to share with us. Now, over to you, sir.
Thank you, Rishabh. Sakshi. Today we are going to discuss the basic conceptions and essence of crime and principle of criminal jurisprudence being changed dimension. First, we discuss the what are the different stages of crime and what are the elements of crime. Then we discuss the basic rules of criminal jurisprudence. Then we discuss the reverse burden of proof. I am audible to all. Is there any problem in hearing?
Yes, sir, you're audible, but not very clearly.
I am audible to all.
Yes, sir.
So we start. First, we discuss the word of crime. Although the word of crime has not been defined, neither in IPC nor in the CIPC, but there is an attempt that has been made under Section 40 and Section 2 and Section 40 of the IPC and Section 2N of the CRPC. Then someone says the word crime is a synonyms. Word offense and the crime is the synonyms of each other, but there is slight difference in the word of crime and the offense. Crime is a broader term which includes the legal as well as the moral wrong, whereas the offense is narrower terms as it includes only the legal wrongs, which is formally declared as an offense. Then we further discussed, now I'm discussing what are the basic ingredients of a crime. First of all, for a crime, what is requirement? The crime has to be committed by a human being. The first essential elements of the crime is human being. It requires that the act to be done. A crime is necessary that act must be committed by a human. Although in the ancient time, where the criminal law was dominated by the idea of retribution, the punishment was also inflicted on the criminal.
Sir,
Yes,
your voice is cracking.
voice is correcting. Just a minute, please. First, now I discuss further. Earlier, in the when there was a theory of retribution, the animals were also punished when the injuries were done by them. But now, if the animals commit anything, now the owner will punish. Section 2 IPC provides that every person shall be liable to be punishment under this code and not otherwise for every act or commission contrary to the provisions thereof, which shall be guilty within the India. And Section 11 defines a person, which is not only includes a natural person but the legal persons also. So the liability under the IPC can be fastened even the legal persons like company. Then second element of the crime is manslaughter, which is a state of mind. The fundamental principle of the crime is that wrongful actus reus, to amalgamate it with the wrongful intention, that is mens rea. To constitute a criminal liability, the principle is that the act does not make one guilty unless the mind is also legally blameworthy. Actus reus represent the physical aspect of the crime, which means the mens rea constitute the mental aspect of the crime. The word mens rea legally denotes the intention to commit the act rather being the motive behind it. Mens rea, the state of mind in our IPC, different words has been used to which denotes the mens rea. Word that is intention. To show like that, I just say intention. Under section 307, the word intention has been used. Voluntarily, it has also been defined in the IPC. Then willfully, it is also deliberately, knowingly. These all are the words which denotes the mens rea, with the state of mind. Definition has also been given in the IPC of certain words denote the intention. There are certain exceptions to these rules. So where there are some acts where the mens rea, even there is no mens rea, even though those acts is said to be a crime, such as negligence. Section 279, 285, 286. In the absence of even in the absence of mens rea, those acts were said to be a crime, even in the absence of mens rea. Then second aspect is actus reus. So to constitute an act, there must be a mens rea, then actus reus. What is the actus reus? Actus reus is a Latin term. The word is wrongful act. The act must be voluntary and the act must be prohibited by law. Not all the wrongs act are the crime. If there is a mens rea as well as the actus reus, then the crime will constitute. Otherwise, crime will not constitute. Then it further says the act must be prohibited by the law. Includes the word illegal omissions. Section 43 defines illegal or legally bound to do. Not only the act done, even the omission has also been an offense. So these are the different elements of the crime. Number one, the crime has to be done by the human being. Number two, there is a mens rea. Number three, there must be actus reus. So this is all about the crime. What is the crime? Now, what are the different stages of the crime? Number one, intention. Number two, preparation. Number three, attempt. These are the different stages of the crime. So we must understand the difference between the elements of the crime and stages of the crime. We must not confuse between these two aspects. What are the intention? Intention is also one of the state of mind. There is a difference between the intention and the motive. Motive is the purpose of the crime of a particular act, whereas the intention is a means to commit the crime, means to commit an act which is not lawful in the accused to commit. So it is clear the intention, there's a difference between motive and the intention. Then second is preparation. Preparation is itself not a punishable act. Preparation, as we define what is the preparation. Preparation is, there's a literal meaning of preparation, to arrange the means necessary for the commission of crime. Generally, the preparation is not a punishable, but there are certain offenses which are graver in nature, is punished is liable to be punished by the IPC, such as Section 122, preparation for sedition, Section 126, Section 333 and 335, then 255 counterfeiting coins, 259, 266, 440, 74, 399, preparation for dacoity. So, where the legislature itself defines that the preparation is punishable, then only the preparation is punishable. Otherwise, no. Suppose I have to commit a murder, I arrange a knife. This is not a punishable act, because it does not, the IPC does not provide any punishment for that. But I arrange means to commit dacoity. We suppose we 5 persons are collectively sitting and planning to commit dacoity. Then it is punishable under Section 399. You must understand the things that preparation is itself not a punishable, but when the legislature said the for a particular offenses, the preparation is also offense, then we have to bear the consequences, such as 399 and etc. Then foremost is attempt. What is the attempt? There is no definition of attempt. Neither the attempt is defined nor the preparation is defined. What is the attempt? The direct movement towards the crime after the necessary preparation being made. So the attempt can be defined like that. The direct movement towards to commit the crime after the necessary preparation being made. In in some case law, I just refer to some case law in state of Maharashtra versus Mohammad Yaqub. Some attempt has been made to define attempt. The stage of attempt reaches when the culprit takes in this judgment, the honorable court to try to define the attempt. The stage of attempt reaches when the culprit takes deliberate or steps to commit crime which need not to be punitive act. So this is was what try to define the attempt. What are the essentials of the attempt? Guilty intention to commit crime, some acts towards commitment of crime, then the act must be fallen short to complete the offense. And now the attempt under the IPC, because our penal law, basic criminal general penal law is Indian Penal Code. Complete offense and the attempt have been specified in the same section, and the punishment has been prescribed for them, such like 307 IPC. Some grave offenses where the attempt is described separately and the specified punishment has been prescribed, such as attempt to murder, attempt to culpable homicide, attempt to suicide, attempt to loot, attempt to dacoit. So punishments were prescribed for the attempt itself. Now there is a general section for to punish the attempt, that is section 511 IPC, where the separate punishments has not been prescribed. Then section 511 attractive. What the section 511 IPC says? Section 511 IPC provides the accused shall be punished with one half of the punishment provided for the commission of the offense. Suppose a person who commit an offense which is not separately, suppose a person tried to commit attempt of an offense which is not separately punishable in the IPC, then section 511 says the person can be punished with the half of the sentence. It is clear? Now, suppose a person try to attempt offense of thuggy that is given under section 310 IPC. Then punishment is half of the punishment, that is life imprisonment. If a person committed the offense of thuggy, that is life imprisonment. Now the question is, if suppose a person commit an offense, commit an attempt of a offense of given under section 310, then half of the life sentence has to be given. Now how it could be calculated? The life cannot be calculated. Mine may be a 40-year, your may be a 80-year. So how we can calculate it? Then section 57 of IPC attracts. For the counting the period of fractions, IPC says the life imprisonment deemed to be 20 years. Then it would be punishable with 10 years. So you must understand what is the meaning of life imprisonment. There is misconception about the definition of a life imprisonment. I just clarify to you. Number one, life imprisonment till last week, the person must be behind the bar. Number one. Number two, there is misconception that 14 years. Then section 433C, where the offense is punishable with death and allied, and court awarded a punishment to a person this allied, then the person has to be remain behind the bar for 14 years. Even the government cannot remit the sentence prior to 14 years. This is the 14 years. Then another question arises: government release a person prior to 14 years also. Then section 433A CRPC, what it said? It says when the offense is punishable with only with life, and the court awarded the sentence of life, then the government has power to remit the sentence prior to the 14 years, 5 years, 7 years, looking at the behavior of a person in a jail, recommendation of superintendent of jail, there is so many. Then another 20 year, as I earlier told you, 20 years is only for the purpose to counting the period of function of the that life imprisonment. Yeah. What happened? I'm audible.
Yes, sir. Yes, sir. You are audible.
I think there was some problem. I'm audible to all.
Yes, sir.
I think. Now, as I define you, what is the meaning of life imprisonment? Now, what are the theory of attempts? In India, there is no as such theory of the attempts. There are two kinds of attempts. impossible attempt or possible attempt. If you read the definition of attempt, on the 511 has not defined the attempt. It only illustrates the attempt. What are the theory of attempts? One is impossible attempt. A person may fail to commit a crime, but is still liable for the criminal attempt if he fails because he was physically interrupted. Word is physically interrupted in his planned course of action. It is generally held he is liable for a criminal attempt if he physically interrupted. Word is, the important word is physically interrupted. Where the accused contemplates his course of action, but the act does not constitute an intended crime. For example, to kill someone who is already dead may be termed as an impossible attempt. And in United States of America, there is distinction has been given factual and legal impossibility. Now, there is some distinction between the impossible attempts also. As there is no difference in India, but in US there is a difference between the impossible attempts also. What are the impossibility? One is factual impossibility, another is legal impossibility. What is the factual impossibility? Factual impossibility is one fails because of some factual or physical condition unknown to the accused makes it impossible. It contemplates that a physical impossibility, such as हमने कोई खाली पर्स उठा लिया, तो it is factual impossibility, impossible attempt. Another is legal impossibility. Legal impossibility, an attempt which is act is fully consummated, does not meet the legal requirement. For example, to kill a person who is already dead. So there is attempts are two kind of attempts: impossible attempt or possible attempt. And there is no distinction in India, but in US, impossible attempts, what does it mean? Impossible attempts is legal impossibility or factual impossibility. So the in India, there is no such distinction has been given in the IPC. But in India, we can apply the object theory. What are the object theory is? The object theory is the cases where the object is merely mistaken and where the object is absent. So in India, we can apply the theory where the object is mistaken or where the object is absent. Where the object is merely mistaken, then it would be attempt. And where the object is absent, then it would not be an attempt. So in 511, the illustration has been given. Attempt, impossible attempt towards the property. The only examples illustration is given in the IPC in 511, the impossible attempts of property towards the property. वो खाली संदूक वाला उदाहरण है. You may take the assistance of this IPC 511 illustration. The attempt, impossible attempt theory, only the illustration is with regard to the given is with regard to the property, not with regard to the body. Where object is absent, then it cannot be said to be an offense. But where the object is mistaken, then it can be punishable in India. So these are the different stages of the crime, such as number one, intention, not punishable at all. Number two, preparation, punishable where the legislature prescribes. Number three, an attempt is punishable where there are some offenses where the separate punishment has been provided, such as attempt to murder, attempt to culpable, homicide, attempt to dacoity. Then where the separate punishments were not given, then we can take assistance of section 511, only half sentence can be awarded to them. So these are the different stages of the crime. So we conclude two topics. Number one, what are the basic elements of the crime? Now, number two, what are the different stages of the crime? Now we discuss the basic principle of the criminal jurisprudence. What are the basic principles of the criminal jurisprudence, which has to be looked during the course of trial? Number one, every person presumed to be an innocence. It is a basic right of accused and account for the rule of fair trial. And it is the most important right of the accused, and all the rights of the accused derive from this right, such as right to keep silence, right for fair trial, doctrine against self-incrimination. We discuss further. Prosecution has to prove the case beyond reasonable doubt. Then burden of proof lies on the prosecution. So number one basic principle is every person presumed to be an innocence, and these are the rights which are derived from this basic principle. Number two basic principle is everyone can bring the criminal law in motion, but there are certain exceptions to this rule, such as 494 bigamy. Only the aggrieved party can file the complaint. You cannot file the everyone cannot file the complaint. Everyone can give the information about the cognizable offense. Everyone can bring the criminal law information. Then there are certain exceptions. Section 195 is suppose a person gives a false evidence before the courts, only the courts before whom the evidence was given can file the complaint before the competent court. So general rule is everyone can bring the criminal law in motion, but there are certain exceptions to that rule, as I give the example to you. Number three, the prosecution has to prove the case beyond reasonable doubt, and it cannot take advantage the lacuna left by the defense. So prosecution has to stand on its own legs. It cannot take advantage or advantage the lacuna and the things left by the defense. Suppose defense counsel कुछ नहीं पूछ पाए, तो prosecution cannot say कि साहब इन्होंने ये नहीं बताया, therefore he is liable for conviction. No, the prosecution has to stand its own legs, and it cannot take advantage of the lacuna left by the defense. This is the foremost principle of the third most principle of the criminal trial. Then limitation in the crime. There is no limitation of the crime because there is a latent maxim: crime never dies. But there are certain exceptions to this rule also. In CRPC section 467 to 473, statutory provisions are there which prescribe the limitation. Suppose the offense is punishable with 1 year, then limitation is 1 year. Another if punishment is for 2 years, then limitation is 2 years. Then if the offense is punishable with 3 years, then the limitation is 3 years. Above, if the offense is punishable with 3 years and more, then there is no limitation at all. The word which has been used by the legislature, this is a very controversial issue, because the legislature used the word no court shall take cognizance beyond the period of limitation. Suppose the offense is 323, punishable with 6 months, 1 year. We take an offense of 1 year. Suppose a person commit a crime on 1st January 2023, 22, and he offense is cognizable. Aggrieved person immediately close the FIR. Are you aware about the stages of the trial? You must understand the stages of trial. Then you can understand this question. Suppose a person lodged the FIR on 1st January 2022. Police investigate the matter and thereafter file the charge sheet in the month of August. After 6 months, then court take cognizance in the month of September. Then it become 9 months. So legislature use the word no court shall take cognizance beyond the period of limitation. Here the case where the courts takes the cognizance beyond the period of limitation, that is 6 months. Limitation expire in the month of June itself. But victim already informed the police within time, then what remains? There is a judgment, there is a constitutional bench judgment on this issue, which says a Sarah Matthew judgment. I provide the citation to all of you, which says the crucial point is information of a crime. Note the crucial point is cognizance taken by the court. So as soon as you inform the authority regarding crime, you close the FIR or you file the complaint under Section 90 CRPC, then your duty ends. So word cognizance has been interpreted by the Honorable Supreme Court, like in Sarah Matthew case, that the important is to inform the authority, not the important is to take the cognizance. So these things you have to keep in mind. Now next is doctrine of strict construction of the criminal law. It is a basic principle of interpretation that all the statutes, criminal statute, has to be interpreted in a strict manner. Now we are confining our discussion only with regard to the basic principle, that is presumption of innocence and burden of proof. Now what is the link between the presumption of innocence in Indian criminal justice delivery system and the concept of rule of fair trial? All the rights of the accused, as I earlier told you, all the right of the accused, right to keep silence, right to keep doctrine of self-incrimination, right fair trial, prosecution prove case beyond reasonable doubt, all the rights derived from this concept. Now, this concept has been recognized by Indian courts by virtue of Article 21. Article 21 says, no person shall be deprived from his right to life and personal liberty except the procedure established by law. And all the rights derived from Article 21, that every person presumed to be, although it is a very, very old concept, but nowadays we can say all the rights are derived from Article 21. And other sections such as Section 20, 24, 25 and 26 of Indian Evidence Act. Now, what does mean the fair trial? Fair trial does not merely means the same should be observed at the time of trial. Rather, it casts a duty upon the courts to discard the evidences which is procured by the prosecution in violation of this precious right. I give the examples and illustration to that and the statutory provisions with regard to that. That what are those? That knowledge of acquisitions to the accused which are inherited under Section 50 of CRPC. We must know why he has been arrested. There are pre-trial observations at Chapter 17 which relates to the charge. That we must know what are the acquisition against me, such as Section 288, 240, 246 and 251 CRPC. It says that person must know what are the acquisition against him. Rule of charge. Then further, it says even the accused has to say. Section 233, 243, 247, 313 CRPC. But we are dealing in our criminal jurisprudence system is adversarial system, and it is inherited under these sections. Even the accused can himself enter into the witness box by virtue of Section 315 CRPC. Even Section 41D says the right of accused to advocate during the interrogation. So all these, अगर इनकी violations के अंदर कोई आपका trial चल रहा है, then it is vitiated. Then third is competence of a judge. Section 29 CRPC, who will be a judge in a particular case. Then Section 479 CRPC, keep check and balance over that. Then fourth is presence of an accused. The every trial must be in presence of the accused. If the accused is not present, then it cannot be said that the fair trial is going on. Section 273 says the every hearing should be in the presence of accused. Then doctrine of self-incrimination, Article 20, Section 161 subclause 2 CRPC, Section 162 CRBC, which says the signing of the statement made, signing of a statement made to the police are not mandatory. If during the course of investigation, police recorded the statement of witnesses, signing of those statements are not mandatory, not even required. And the statement recorded during the course of investigation is only can be used only for the contradiction as per the proviso under section 132 of Indian Evidence Act. They cannot be used, and even the statement recorded by the investigating agency are not admissible. Section 24, 25, and 26 of Indian Evidence Act. So, number 6, benefit of doubt. Our system says 100% may be left unpunished, but not a single person who has not committed crime should not be convicted. So अपराधी छूट जाए बट एक निर्दोष को सजा नहीं होनी चाहिए, ये हमारा बेसिक प्रिंसिपल. सो दीज आर द 6 प्रिंसिपल. नंबर 1, एक्यूज को पता होना चाहिए कि उसके खिलाफ क्या एक्विजिशन है जो अपने ऊपर चार्ज लगते हैं. नंबर 2, एक्यूज को डिफेंड करने का राइट है, उसको सेक्शन 233, 243, 313. नंबर 3, even he can appear as a witness, section 350. Number 3, it says the competency of judge, section 29 CRPC, 479 CRPC. Then presence of accused, then doctrine of self-incrimination, then benefit of doubt. Then I further discuss the burden of proof. As we all know, as I discuss also, the burden of proof always lies on the prosecution. It is a basic principle. But there are certain exceptions to this rule also. Burden of proof never shifts. You must understand there's a difference between onus of proof and burden of proof. Burden of proof is a proving a case. That prosecution has to prove the case beyond reasonable doubt. Suppose we had taken the example 302 CRPC. The prosecution को ये साबित करना पड़ेगा beyond reasonable doubt that X person who has committed the murder. And onus of proof is a proving a facts within a case. Suppose उस पूरी ट्रायल के अंदर accused एक plea लेता है, plea of alibi, then burden lies upon him. So you must understand the burden of proof never shifts. It always lies upon the prosecution. But the onus of proof shifts. The person who is taking a specific plea, either it may be a prosecution, it may be a defense. The burden lies upon them who are taking a specific plea. This burden of proof, this reverse. I just do it. There is a difference between burden of proof and onus of proof. Burden of proof is proving a whole case. Suppose we are taking an example, मैंने आपको इसको और एलोबरेटली थोड़ा डिस्कस करूं. एक ट्रायल चल रही है, मर्डर की ट्रायल चल रही है. मर्डर की ट्रायल के अंदर प्रोसिक्यूशन एक ये चीज लेकर आता है कि सब ये नाइफ है जिससे मर्डर हुआ, उस नाइफ के ऊपर ब्लड लगा हुआ है, वो एक्स आदमी का है. सो नाउ द ड्यूटी अपॉन द प्रोसिक्यूशन टू प्रूव दिस इज द नाइफ by which the murder has been committed. First, the prosecution has to prove the entire case. I am the person who has committed the murder. This burden has never shifted. It is always lies upon the prosecution. But onus, what is the onus? Onus of proof, proving a fact, a special fact within a case. Suppose accused taken a plea that I was not there, I was not present at the place of incident. Then it is for the accused to prove that plea. Insanity की plea लेता है, it is for the accused to prove that plea. If the accused said, no, sir, act was done bona fidely, it is not punishable, I comes under covered under the general exceptions, then it is for the accused to defend. So you must understand, onus of a proof may shift, but burden of the proof never shifts. So I think it is clear. Or if you have any query, then discuss to me further. So now you understand the difference between the burden of proof and the onus of proof. So burden of proof always lies upon the prosecution. This is a basic general principle. Now, it is a very, very old law. Now we have to discuss, now there is a trend to reverse burden of proof. Now you can see the every enactment is having a clause of presumptions. I can give you example of NDPS Act, Narcotic Drugs and Psychotropic Substance Act, POCSO Act, Prevention of Child from the Sexual Offences Act. Why are the requirement of those? There are some traditional crime also where the burden of proof, where the reverse burden of proof has been given. Section 304B IPC, dowry death. Why this section has been enacted? Why this section has been enacted by the legislature separately? 304B. What is the 304B? 304B, the dowry death. What are the basic ingredients of that? Suppose 304B says, suppose a woman died within unnatural circumstances. A woman died unnatural circumstances within 7 of year marriage, and it is so that she was soon before her death, she was subjected to the cruelty before the demand of dowry. Then Section 300 113A of Indian Evidence Act says, if these facts presume that the court shall presume that the person is guilty of the offense. Here, the burden of proof relaxed by the legislature. Now it is for the accused that he is not guilty. Why this has been enacted? What are the object behind this? We must understand this. That's why we can understand why there is a reverse burden of proof. There are crimes which are very close. The crimes were committed within the four walls of a room. पहले जो बच्चियों के साथ क्राइम होता था वो बड़ा क्लोज रूम में होता था. वहां पे वो ससुराल के अंदर, अपने घर से ससुराल के अंदर है, वहां पर कोई उनके पास विटनेस नहीं मिलता था. 302 का चार्ज लगा दिया. 302 में तो वही बर्डन ऑफ प्रूफ, प्रोसिक्यूशन हैज टू प्रूव द केस बियॉन्ड रीजनेबल डाउट. वहां कोई उनके पास विटनेस नहीं है, फोर कॉर्नर्स के अंदर क्राइम हुआ है, पड़ोसी कोई गवाही नहीं देता था. देन एक्यूज एक्विट हो जाता था. देन लेजिस्लेचर थिंक्स ओवर इट, लॉ कमीशन थिंक्स ओवर इट. देन द लॉ कमीशन, में वो बताऊंगा आपको, लॉ कमीशन, देयर इज कमिटी ऑफ लॉ, देयर इज अ रिपोर्ट ऑफ अ लॉ कमीशन आल्सो ऑन दिस इशू. Then the legislature enacted 113A in the Indian Evidence. Presumptions was given. If once these ingredients were completed, then court has to attract the presumption. Now again the burden lies upon the prosecution. So this is the reason behind to enact the law of reverse burden. These are the reasons: white collar crime, cyber crime, sexual offenses crime, crime against women, जो four corners में होते. These are the reasons which forced the legislature to enact such kind of law. Therefore, the presumptions were enacted, incorporated in all these kind of special enactments. Then one committee was constituted by the legislature. Why? These are the reasons. As I earlier told you, the method of the crimes and the concepts to commit the crimes are different, which force the legislature to enact such kind of rule of evidence. A committee headed by Justice V.S. Malimat was constituted, which says the system devised more than a century has back and become ineffective. A large number of guilty go unpunished in a large number of cases. The system takes years to bring the guilty to the justice, has ceased to deter the criminals. Crime is increasing rapidly every day. The types of crime are so the citizen live constant fear. These the committee has submitted the report. These are the reasons because our evidence act was so old, therefore it requires some changes. Therefore, even the committee has suggested to add a new chapter in the IPC for such crimes such as cyber crime, such as white collar crime, such as sexual crimes. But then another report came which suggests no, it should not be in the IPC, but it should be via some special laws. Therefore, special law were enacted, such as Enforcement Direct (PMLA), such as NDPS Act, such as POXO Act, such as Domestic Violence Act. Therefore, therefore, in all these acts, the presumptions has been given. Although there is some controversy over this, some criticize this. This is again the basic principle of the criminal jurisprudence that every person presumed to be innocence, but your presumptions are you are this is the violation of the basic human rights. But looking into the ineffectiveness of our investigating agency, because our investigating agency is not so highly equipped to investigate the matter, therefore all these presumptions were attracted. Now, what are the presumptions? There are legal presumptions also. There are rebuttable presumptions also. There are inconclusive presumptions also. So we must understand that the presumptions which are incorporated by the legislature are examples of the reverse burden of proof. And reverse burden of proof are criticized by by in some judgments also. You must read the judgment, a very good judgment on the issue of rule of evidence is Noor Aga judgment. It is on the NDPS Act. So I conclude this. If you may have a query, please ask me. I just conclude. I just summarize what I read to you. First, we discuss what are the basic elements of the crime. That is, number one, is crime must be committed by a human being. There's mens rea and actus rea. These are the basic elements. Number two, we discuss what are the different stages of the crime. Number one, intention. You must understand the difference between intention and motive. Number two, preparation. Preparation itself not an punishable act, but the legislature has provided some preparation is also punishable. Number three, we discuss the attempt. There are some offenses where the attempt is itself an offense. 307, three attempt to rape, attempt to murder, but where there is no definite punishment was prescribed, we can take help the 511 half punishment can be given. Then we discuss the theory of attempt, that impossible attempt, possible attempt. What are the legal and factual? In India, we can take advantage of object theory, where the object is mistaken or object is absent. Then we further discuss the basic principle of the criminal jurisprudence, basic principles as we discussed. The presumes number one, every person presumed to be an innocence. Number two, that uh, everyone can bring the criminal law in motion. There are certain exceptions to this rule also. Number three, prosecution has to prove the case beyond reasonable doubt. It cannot take advantage of the lacuna left by the defense. Number four, law of limitation. There is exception to that rule also. Then doctrine of strict construction, we discussed it. Then we further discuss the reverse burden of proof and presumptions. If you have any query, then you can ask. Sakshi? If anyone have a query, please ask. Anyone want to discuss anything?
Sir, there is a question uh, by Kalpana Kumari. Sir,
Yes, yes.
what is the difference between impossible and possible attempt?
As I told you, what is the impossible time? I just explained earlier. A person may fail to commit a crime, but still liable for a criminal attempt. If he fails a crime because he was physically interrupted, word is physically interrupted in his planned course of action, it is generally held liable for the criminal attempt. Then again, this is the impossible attempt. When the accused contemplates his course of action but act does not constitute intended, for the example, to kill someone who is already dead. देखिए, when the object is mistaken, then it is impossible attempt. When when object is absent, then it is impossible possible attempt. When object is mistaken, that is it is impossible attempt. In India, there is no distinction as such, but we can take advantage of this. In when the object is mistaken or object is absent, you can explain this. When the object is absent, then it is impossible. When object is absent, that is it is possible. Any other question?
Sir, there is one more question by Aman Kumar Yadav. Apart from counterfeiting and dacoity, where the preparation shall be deemed to be crime?
Yes, section 122, preparation for sedition. Section 126, section 333 and 335, preparation to commit crime towards the public servant. There are so many crimes which are given. You can note down 122, section 122, 126, 335 to 333, 255 to 257, 242, 259, 266, 447, 399. There are so many offenses which are where the preparation itself and crime. Object theory.
Sir, there is one more question by Sir Jayeta Mark. Ownership of proof. Can you explain again, sir?
The burden of proof is a proving a whole case. Suppose a person is charged for the charged for commit a murder, then it is for the prosecution to prove beyond reasonable doubt that he is the person who commit the offense. But suppose a specific plea is taken even by the defense or by the prosecution, that those particular plea has to be proved that by even by the defense or by the prosecution. That is called onus. Onus is burden of proof is proving a case. Onus of proof is proving a fact within a case. onus of proof तो हो गया एक बड़ा सर्किल, और सॉरी बर्डन ऑफ प्रूफ तो हो गया एक बड़ा सर्किल, और ओनस ऑफ प्रूफ होगा उस बड़े सर्किल के अंदर छोटे छोटे कई सर्किल्स. जो भी स्पेसिफिक प्ली ले रहा है उसको वो स्पेसिफिक प्ली प्रूव करनी पड़ेगी. दैट इज ओनस ऑफ प्रूफ. देन अगेन ऑब्जेक्ट थ्योरी. ऑब्जेक्ट थ्योरी इज where the object is mistaken or object is absent. Object is mistaken, आप समझिए मैं एक कोर्ट टक रहा है, मैंने सोचा कि एक्स आदमी है, मैं उसके ऊपर गोली चलाता हूँ, मैंने फायर किया और उस कोर्ट में लग गई, दैट इज ऑब्जेक्ट इज मिस्टेकन। अब मैंने एक्स आदमी को मारना और एक्स आदमी ऑलरेडी डेड है, वो ऑब्जेक्ट इज एब्सेंट। आई थिंक नाउ यू अंडरस्टैंड दैट। तो वेयर ऑब्जेक्ट इज मिस्टेकन, दैट इज पनिशेबल, वेयर ऑब्जेक्ट इज एब्सेंट, दैट इज नॉट पनिशेबल। I think that may be it is clear to all of you.
Sir, there is one more question.
Imprisonment for life.
Yes, sir. Imprisonment for life.
देखिए, आप समझिए इस चीज को ऐसे समझिए। Imprisonment for life, what is? We have some misconception about, अब एक थ्योरी ये चलती है कि जेल के अंदर दिन रात सजा चलती है, ये भी एक मिसकंसेप्शन है। तो अपन कहते हैं कि जेल के अंदर तो एक दिन के 2 दिन काउंट होते हैं, ये सब मिसकंसेप्शन है। लाइफ इम्प्रिजन मीन्स life imprisonment. The person should spend his entire life in jail. Number one, you must clear this. And what is 20 year? Some person says कि life imprisonment means 20 year. मैंने आपको example दिया था. Only just to count the period of fractions, you can deem that life is 20 years. Suppose a person who commit an offense which is punishable with life only, he commit the attempt of that punishment, that offense, then how the court can award the half of the life? Then court deemed the life is 20 years, then court will award the sentence 10 years. Number two. Number three, 14 year. What is 14 year? 14 year is section 433 says CRPC. If the offense is punishable with death and LI, and court award the sentence only LI, then government cannot remit the sentence less than 14 years. The person has to expend the 14 years in jail. Then next, कई बार 5 साल में 7 साल में छोड़ देते हैं. What is that? That is if the offense is punishable only with the LI, life imprisonment, and court awarded the LI, then government can remit the sentence even less than 14 years. These are the 4 meaning. And what is the concept कि जेल के अंदर दिन रात चलती है, वो है रेमिशन. गवर्नमेंट को पावर है रेमिशन देने की. सेक्शन 433 सीआरपीसी सेस रेमिशन जो होता है, रेमिशन डिफरेंट काइंड ऑफ रेमिशन होता है. नंबर 1, जेल के अंदर अर्न रेमिशन होता है. जैसे जो आप देखिए सजा जो दी जाती है, वो सजा कई बार देते हैं सिंपल इम्प्रिजनमेंट. अनदर काइंड ऑफ इम्प्रिजनमेंट इज रिग्रेस इम्प्रिजनमेंट. रिग्रेस इम्प्रिजनमेंट सश्रम कारावास होता है, कठोर कारावास. उसमें जेल में आपसे काम करवाया जाता है. सिंपल इम्प्रिजनमेंट में आपसे काम नहीं करवाया जाता. तो जो रेमिशन होती है वो कैसे रेमिशन होती है? एक तो होती है स्टेट रेमिशन. स्टेट के रूल्स बने हुए हैं. बिकॉज इन इंडिया देयर इज अ रिफॉर्मेटिव थ्योरी ऑफ पनिशमेंट. इवन आफ्टर द पर्सन इज कन्विक्टेड he had a chance to reform himself. इंडिया के अंदर थ्योरी ऑफ पनिशमेंट दो डिफरेंट काइंड ऑफ थ्योरी ऑफ पनिशमेंट है. वो है रेट्रिब्यूटिव थ्योरी, डेटरेंट थ्योरी. बट इन इंडिया वी हैव अ रिफॉर्मेटिव थ्योरी. So granting a parole to a convict person, कि 1 साल, suppose a person who is convict, if he served his half of the sentence, 10 साल की सजा थी, 5 साल उसने भुगत लिए, तो उसको every year अब उसको फर्स्ट ईयर 20 ईयर की पैरोल, 20 डेज की पैरोल मिलेगी. वो 20 दिन अपने घर जा सकेगा, अपने घर देख के आ सकेगा. नेक्स्ट ईयर उसको 30 डेज की मिलेगी, उससे नेक्स्ट ईयर उसको 40 डेज की मिलेगी. तो दीज आर द पार्ट ऑफ रिफॉर्मेटिव थ्योरी. इज अ पैरोल. देन अनदर इज ओपन एयर जेल. आफ्टर हैविंग सम सफिशिएंट टाइम, सपोज एलआई कन्विक्ट को 7 साल 8 साल 9 साल जेल में हो गए, वो ओपन एयर जेल में रहते हैं. ओपन एयर का कंसेप्ट ये है कि आदमी पूरे दिन जाके बाहर काम करके आ सकता है. सुबह 7 बजे जाएगा, शाम को 5-6 बजे आके उसको जो भी टाइम है जेल का मैनुअल के हिसाब से उसको अपना वापस आके जेल में रात को वहां रहना पड़ेगा. दिस इज ऑल्सो वन काइंड ऑफ थ्योरी ऑफ रिफॉर्मेटिव थ्योरी. देन रेमिशन. रेमिशन में है कि आप उसको जेल के अंदर उसके कंडक्ट को देख के, एक होता है स्टेट रेमिशन. स्टेट ने रूल्स बना रखे हैं कि अगर एक जेल रिपोर्ट होगी उसका जेल का कंडक्ट अच्छा होगा तो उसको महीने के अंदर हम 3 दिन का रेमिशन दे देंगे. तो उसके लिए महीना कितने दिन का हो गया? 27 डेज का. दूसरा होता है अर्न रेमिशन। अर्न रेमिशन क्या होता है कि जेल में जो काम करते हैं तो उनके लिए 2 दिन या 3 दिन दे दिए। सपोज एक आदमी का जेल कंडक्ट अच्छा है, उसको अर्न रेमिशन मिल रहा है, तो उसको 6 दिन मिल गए। देन अनदर इज स्पेशल जेल कंडक्ट, जो सुपरिटेंडेंट ऑफ जेल है, ही हैज पावर लुकिंग इनटू द कंडक्ट ऑफ दैट पर्सन। 3 दिन उसने दे दिए तो 9 दिन हो गए। फिर स्पेशल रेमिशन आता है, गवर्नमेंट 26 जनवरी 15 अगस्त को छोड़ देती है, वो स्पेशल रेमिशन। तो इस तरह से उसका महीना 20 दिन का हो गया। तो ये जो जेल के अंदर दंडास सजा चलती है वो ये कंसेप्ट है, रेमिशन का कंसेप्ट है। तो जो लाइफ इम्प्रिजनमेंट का मीनिंग है वो सिर्फ ये है, लाइफ मीन्स टिल डेथ, another for 20 years is just to count the period of fraction, 14 years is death or ally awarded by the court, then he has to serve the sentence 14 years in the jail. Third one is, if suppose a person or punishable, the offense is only punishable with a life imprisonment, and court awarded the sentence life imprisonment, then government can release him prior to 14 years old. I think now you must be clear. Anything else? What are the basic principles which change
Yes, sir.
the
There is one more question. What is the principle of criminal jurisprudence with the change dimension means,
देखिए,
which is in the topic?
I just explained to you what is the meaning of it. The basic principle of criminal jurisprudence is that every person presumed to be an innocent until and unless held guilty. Then another is the prosecution has to prove the case beyond reasonable doubt. Change dimension is nowadays in every enactment you find that that those basic rights has been taken away by the legislature while incorporating the reverse burden of proof. Now you find, suppose, such as section 37 of NDPS Act, as we all read during our LLB, that bail is a rule, jail is an exception. We all read it. But section 37 NDPS says that the accused, the court, even at the time of granting bail, has to give the finding that this person is not guilty of the offense. How it is possible? It is a very stringent condition for granting the bail. This is the divergence from the basic rule of the criminal jurisprudence, such as POXO Act. POXO Act, there is a presumption under section 29 that if there is an accusation has been leveled, that the court will presume that he is guilty. Now it is for the accused to prove that he is not guilty, which is also one of the which is against the basic principle of rule in the change dimensions. In POXO Act, in entire criminal system, the basic concept of cross examination. Even in the POXO Act, you will find that first you have to prepare a questionnaire, you have to supply those questionnaire to the presiding officer. Presiding officer allow those questions only. Presiding officer will allow only the question which he thinks fit to ask to the victim. So this is also against the basic principle of criminal jurisprudence. Now it is in changing scenario, changing dimension. Then PMLA Act, Enforcement Directive, Prevention of Money Laundering Act. Again, reverse burden has been given. Again, stringent condition for granting bail. So you will find nowadays all the enactment with the change change burden of change rule of evidence. You will find that. Therefore, the name of topic is basic principle of criminal jurisprudence with change dimension. And anything else?
Now, I would like to express my heartfelt appreciation to our exceptional speaker, who generously shared their insight, experience, and expertise throughout this webinar. Thank you so much, Kapil sir, for joining us today, for sharing your valuable knowledge with us. It was an honor to have you with us, sir. Further, I also like to thank Mr. Amit Swami sir for helping us to organize this event. Thank you so much, sir. Now, I also like to thank our participants who have joined us today. Thank you all, and we will provide the feedback form in the group. Have a good day. Thank you, sir.